Remember that one morning when millions of us woke up to discover that the federal government had reclassified our owned firearms, threatening penalties if we didn't comply? That kind of bureaucratic power grab is infuriating. It's a clear violation of our rights. But help is on the way, and it's coming from a very unlikely source. In this video, we'll talk about the new push in Congress to permanently halt these unfair restrictions on short-barreled rifles and pistol braces, and what that means for lawful gun owners nationwide. Whether you own a braced pistol or support the right to bear arms on principle, this is a moment that could reshape our Second Amendment freedoms in a big way. For far too long, the federal government has used bureaucratic maneuvers to regulate firearms based on accessories or barrel lengths rather than the actions of the people who own them. It's not a crime to own a tool, yet these agencies have labeled millions of peaceable citizens as potential felons through arbitrary definitions. That's what happened when the current administration classified pistols with stabilizing braces as short-barreled rifles, subjecting them to the National Firearms Act. Owners were forced to register under an amnesty scheme or face legal consequences. The response to that rule was massive. It was nothing but government overreach, relying on an 89-year-old law to justify modern-day registration. Luckily, the Mock versus Garland case stopped the brace ban from taking effect nationwide, at least temporarily. In that case, the judge recognized serious legal questions about the ATF's authority and the harm imposed on ordinary Americans. The fact that millions of us could be transformed into criminals overnight was a glaring example of bureaucratic abuse. Although this ruling is a welcome pause, it isn't the final word. Appeals and potential regulatory workarounds show that we need a more permanent shield against these ever-shifting definitions. New legislation in Congress aims to provide that fix. Its central purpose is to remove short-barreled rifles, short-barreled shotguns, and related items from the National Firearms Act altogether. If it passes, the brace ban collapses because it no longer has the legal basis of SBR classification. That means no tax stamps, no protracted registration, and no criminalizing honest people over a technical detail. This effort strikes at the heart of one of the oldest and most intrusive federal gun control structures, effectively cutting off the ATF's ability to treat a pistol with a brace as something sinister. Since 1934, the NFA has burdened us with fees and paperwork, even though a shorter barrel doesn't magically turn a firearm into a greater threat. Bureaucrats have steadily broadened what falls under federal scrutiny, and the brace fiasco is just the latest. We see a pattern. Each time the government reinterprets a rule, more ordinary people must jump through hoops or risk felony charges. It's a recipe for confusion and entrapment, and it has nothing to do with stopping actual criminals who ignore every regulation anyway. So, what's this bill all about? Well, we already talked about it in a previous video. It's called the Stop Harassing Owners of Rifles Today, or SHORT Act. If it passes, it'll do a few key things. First, it eliminates SBRs and SBSs from the NFA, so owners avoid the $200 tax stamp, invasive forms, and long wait times. Second, it orders the ATF to destroy all records of these items within a year, removing any centralized data that the agency might misuse. That wipes out the amnesty registration logs and ensures a fresh start without lingering databases. Third, it prevents states from adding their own taxes or registries to items no longer regulated federally. This is crucial for places like California or New York, where lawmakers lean on NFA definitions to justify bans. Without that label, those prohibitions start to lose their legal footing. Finally, it tears away the foundation that Biden's pistol brace rule used as justification. If there's no SBR classification, there's no need for amnesty registration or felony threats. Millions of gun owners who rely on braces for safer shooting, whether due to physical limitations or personal preference, would no longer have to fear that a simple accessory could put them behind bars. Remember earlier when I said it's from an unlikely source? Let's talk about the main force behind this proposal in the Senate. Senator Roger Marshall, affectionately known as Doc, is a curious advocate for Second Amendment rights within the U.S. Senate. His background deviates from the typical political trajectory, encompassing roles as a physician, Army Reserve veteran, and farm-raised Conson. Over his 25-year medical career in Great Bend, Kansas, Dr. Marshall delivered more than 5,000 babies, offering him profound insights into the intricacies of healthcare and the burdens imposed by bureaucratic red tape. His 7-year tenure in the Army Reserves further exposed him to the complexities of governmental policies and their tangible effects on individuals' daily lives. Now, something that's weird about Doc Marshall, though in a good way, is his staunch support for gun rights contrasts with prevailing trends among his professional peers. In general, people in the medical community view firearm-related injuries as a significant public health concern, advocating for measures like physician-led counseling on gun safety and stricter gun control policies to mitigate firearm-related deaths and injuries. And about his military background, you know how it is with military men? They're all trained extensively in firearm use, but there exists a weird perspective among them regarding civilian firearm ownership. Discussions within military circles at times reveal their condescending assertion that civilians should never own firearms because they aren't subjected to the same level of training that these military men have. In addition, there are concerns about firearm-related suicides among veterans, which is why, in general, military men don't like guns. Despite these general trends, Senator Marshall has consistently championed Second Amendment protections. He has actively opposed legislation perceived as infringing upon gun rights, including voting against measures he termed gun-grabbing schemes. In addition, he has also led initiatives questioning the Department of Justice on actions that could be interpreted as undermining Second Amendment freedoms. His sponsorship of the SHORT Act really shows his commitment to rolling back regulations he views as overextensions of federal authority in firearm regulation. Senator Marshall's advocacy reflects a belief that constitutional rights, particularly the right to bear arms, should remain uninhibited by excessive governmental intervention. His unique blend of medical, military, and agricultural experiences informs his perspective, highlighting a conviction that individual liberties are paramount and must be vigilantly protected against encroachment. He's joined by co-sponsors from states that value the Second Amendment as a basic right. These senators and representatives have heard from their constituents who are outraged by the brace ban. They realize that the NFA is an outdated framework that has done little to stop crime, but a lot to hassle law-abiding owners. The matching version in the House is spearheaded by Representative Andrew Clyde, who also sees the government's reclassification spree as unacceptable. Supporters include major Pro-2A groups like Gun Owners of America and the National Association for Gun Rights. They know if we don't draw a line now, the ATF could target something else next. One major reason this matters is that state-level bans often piggyback on federal classifications. California deems SBRs illegal, in part because the federal government labels them as restricted items. If that label goes away, California's ban faces a serious challenge. Similar ripple effects could unfold in other states, forcing them to reconsider legislation built on NFA definitions. This might encourage a wider rollback of restrictions that do nothing but trap responsible gun owners in a bureaucratic maze. It also addresses the broader problem of administrative overreach. We've seen how easily agencies can twist definitions to suit a policy goal, effectively turning legal firearms into contraband with the stroke of a pen. That's no way to govern. Criminal law should come from elected representatives who answer to voters, not from agencies looking to expand their domain. Removing short-barreled firearms from the NFA cuts off a major path that regulators have used to penalize us for simply owning hardware that's already protected by the Second Amendment. We also have parallel legal battles. The brace ban is paused thanks to Mock v. Garland, but court decisions can be reversed or circumvented. A legislative fix ensures that even if one court decision fails, we aren't back to square one. That's why we need lawmakers willing to craft long-lasting structural changes to these flawed regulations. Simply blocking them in court is a temporary stopgap, whereas changing the law removes the problem at its source. Another bill in the works is aimed at national concealed carry reciprocity. That measure would let us carry our firearms across state lines without worrying that crossing an invisible boundary could make us a criminal. It fits the same principle. The Constitution doesn't say our rights stop at a state border, nor does it say they can hinge on minor technicalities. The more we simplify these rules, the harder it is for anti-gun forces to exploit them against honest people. Gun control supporters insist these kinds of reforms are dangerous, but we know criminals don't fill out forms or pay taxes on their guns. They're operating outside the law entirely. By contrast, we follow rules and go through legal channels. Why should we be the ones penalized? If officials truly care about stopping violence, they'd focus on the small percentage of offenders who commit most violent crimes, not law-abiding folks who prefer a pistol brace for comfort or need one for medical reasons. Braces in particular help disabled shooters, elderly shooters, and even novices maintain better control over their firearms. That's safer for everyone involved. Turning these devices into contraband is a slap in the face to people who rely on them, implying that the government would rather hamper ordinary citizens than address genuine threats. It shows how misguided these bans can be, punishing those of us who strive to stay compliant while criminals do whatever they want. If this legislation succeeds in both chambers, it'll be a significant blow to the misguided notion that a braced pistol or a short barrel transforms a firearm into a menace. It takes direct aim at the root of the problem, the classification itself. By eliminating it, we remove the ATF's ability to keep tinkering with definitions every time they see an opportunity to expand control. We're saying we've had enough of living under threat from rules that change based on an agency's mood. That said, passing it isn't guaranteed. The Senate poses the biggest hurdle, with the filibuster requiring 60 votes. We've seen good bills falter there. That's why our involvement is crucial. Lawmakers need to hear from us, emails, calls, local meetings, so they realize we won't back down. The Second Amendment is non-negotiable, and any politician who thinks otherwise should be reminded that elections have consequences. When enough of us raise our voices, we can shift the political balance in favor of freedom. Every time a new gun control scheme rolls out, our determination should grow. We've been told these laws are about saving lives, but the track record shows they mostly penalize the innocent. Meanwhile, repeat offenders roam the streets. It's time we focus on real solutions. This legislation offers a chance for Congress to correct course by dismantling one of the key pillars that overzealous regulators have relied upon for decades. We also can't forget that this push aligns with a fresh wave of pro-2A sentiment in Congress. Lawmakers see how the pistol brace controversy sparked nationwide backlash, and they're realizing the NFA's days may be numbered if enough voices join together. This is our chance to stand firm and insist on lasting change. For me, personally, this legislation is a turning point in our fight for the Second Amendment. Our rights have been under siege by endless rules and shifting definitions, and it's time we had a real victory. But how likely do you think this bill actually makes it into law? Comment below, and please like, share, subscribe, and click on the bell icon for more of these videos. We have to stay vigilant, spread the word, and keep demanding that our elected officials honor the Constitution. Stay strong, keep believing, and never doubt our collective power to defend liberty. Thanks for watching. Stay safe.